I was staring at my water bill when I realized something was very, very wrong. The number on the screen didn't make sense. My well water was free. I had drilled that well myself 6 years ago when I bought this property in Cedar Hills, Oregon, specifically to avoid municipal water costs. Yet here I was, looking at a bill for $12,000 in unauthorized water usage fees from the Cedar Hills Homeowners Association. My name is Wesley Quinn, and I'm a 42-year-old software engineer who moved out here to get away from the noise of Portland. I bought 5 acres on the edge of the neighborhood, technically within HOA boundaries, but far enough from everyone else that I thought I'd have peace. The property came with water rights, which was one of the main reasons I chose it. I spent 3 weeks and $15,000 drilling a well that hit a beautiful aquifer at 280 feet. I called the HOA office immediately. A woman with a nasally voice answered on the 4th ring. Cedar Hills HOA, this is Patricia speaking. Hi, Patricia. This is Wesley Quinn from 1847 Pinecrest Drive. I just received a bill for $12,000 for water usage. There must be some mistake because I have my own well. There was a pause. Let me transfer you to our president, Brenda. The hold music was an tinny instrumental version of a song I couldn't quite place. After 2 minutes, a sharp voice cut in. Mr. Quinn, this is Brenda Hutchins, HOA president. Your bill is correct. How can it be correct? I use my own well water. I'm not even connected to any HOA water system. Mr. Quinn, according to our records, you've been providing water to the entire Pinecrest subdivision for the past 4 years. We're billing you for the infrastructure maintenance costs. My brain stuttered trying to process that. I've been providing what? That's impossible. My well only connects to my house. I suggest you check your property more carefully, Mr. Quinn. We have documentation. This bill is due within 30 days, or we'll be forced to place a lien on your property. She hung up before I could respond. I sat there holding my phone, feeling like I'd just been hit by a truck. Providing water to the entire subdivision. That was insane. I walked outside, following the water line from my well house. It was a small structure I'd built myself, about 10 feet by 10 feet, with a pump system that fed directly to my home. Except when I opened the well house door, I found something that definitely hadn't been there the last time I checked. Someone had installed a massive splitter system on my main line. Professional-grade equipment, the kind that costs thousands of dollars. 3 additional pipes branched off from my main water line, each one running underground in different directions. There were meters, pressure regulators, and a control panel I'd never seen before. I felt my hands start shaking. Someone had come onto my property and tapped into my well. Not just a little tap either. This was a full distribution system. I grabbed my phone and took pictures of everything, then called a lawyer. My buddy Marcus had recommended a property attorney named Jennifer Caldwell when I bought the place. I found her card in my desk drawer and dialed. Caldwell Law Office. Hi, I need to speak with Jennifer Caldwell. It's an emergency regarding property rights. She's with a client, but I can schedule you for next week. No, you don't understand. My HOA has been stealing water from my private well, and now they're trying to bill me $12,000 for it. There was a brief silence. Hold on. 2 minutes later, a woman's voice came on. Mr. Quinn, this is Jennifer Caldwell. Tell me everything. I explained the situation while walking back to the house. She listened without interrupting. Okay, she said when I finished. First, don't pay that bill. Second, document everything. Third, I'm coming out there tomorrow morning at 9. Don't touch anything else in that well house. And Mr. Quinn, this is theft on a massive scale. We're talking criminal charges, not just civil. I barely slept that night. I kept thinking about all the times over the past few years when I'd noticed my water pressure was lower than expected, or when the well pump seemed to be running more than it should. I chalked it up to normal variation, maybe a small leak somewhere. It never occurred to me that someone was systematically stealing my water. At 8:30 the next morning, I was already outside when Jennifer pulled up in a silver Lexus. She was a tall woman in her 50s with sharp eyes and an all-business demeanor. "Show me," she said after a brief handshake. We walked to the well house. She spent 20 minutes examining everything, taking her own photos, making notes on a tablet. "This is sophisticated," she said finally. "This wasn't some amateur job. Someone hired professional plumbers to do this. The equipment alone is probably $15,000 worth. How is this even legal? This is my property." "It's not legal. It's theft, it's trespassing, and depending on how this plays out, it could be fraud and conspiracy. The question is who authorized it and when it happened." The HOA president said they have documentation that I've been providing water for 4 years. Jennifer's expression hardened. "They created false documentation to cover their crime. That makes it worse. We need to find out exactly how many homes are connected to your well." She made some calls. By noon, we had a hydrologist and a private investigator on site. The hydrologist was a middle-aged man named Robert Chen who specialized in water rights cases. "This is extraordinary," Robert said, examining the distribution system. "Your well is probably supplying at least 30 homes based on this pipe configuration. Let me check your well's output capacity." He spent an hour running tests while the private investigator, a former cop named Dale Morrison, started tracing the pipelines. "Your well produces about 20 gallons per minute," Robert told me. "That's good for a residential well, but if it's been supplying 30 homes for 4 years, you've probably shortened its lifespan significantly. We're talking hundreds of thousands of gallons of water theft." Dale came back covered in dirt. "I followed the main trunk line. It connects to the subdivision's internal water distribution network about 200 yards from here. There's a valve system that someone can shut off from the street level. Very clever setup." Jennifer was typing rapidly on her tablet. "We need to move fast. First, we're going to shut off their access to your well immediately. Second, we're filing criminal complaints with the county sheriff and the district attorney. Third, we're filing a civil suit against the HOA for theft, trespassing, and property damage. We'll be asking for damages in the range of $500,000 minimum." $500,000. "Mr. Quinn, they stole years' worth of water from you, installed equipment on your property without permission, likely decreased your well's lifespan by decades, and are now trying to extort money from you for their crime. $500,000 is conservative." Dale had already located the main shut-off valve where my water connected to the neighborhood system. He turned it off with a loud metallic clang. "That's going to get their attention," he said with a grim smile. It took less than an hour. I was inside reviewing documents with Jennifer when I heard a car door slam. Then another. Then several more. I looked out the window to see 6 people marching up my driveway, led by a woman in her mid-50s with blonde highlights and an expression that could curdle milk. She was wearing designer athleisure wear and sunglasses that probably cost more than my monthly grocery bill. "That's going to be Brenda," Jennifer said, looking over my shoulder. I opened the door before they could knock. Brenda didn't even pretend to be polite. "What the hell do you think you're doing?" she demanded. "You just shut off water to 43 homes." "Get off my property," I said calmly. "Excuse me." Jennifer stepped up beside me. "I'm Jennifer Caldwell, Mr. Quinn's attorney. You're trespassing." "Leave immediately, or I'll call the sheriff." I'm the HOA president and I have every right to be here discussing community issues. You have no rights here whatsoever. You've been stealing water from my client's private well for years, and now you're attempting to extort him. Leave now." Brenda's face turned red. "Stealing? We have a contract. Wesley signed an agreement when he bought his property that he'd provide water to the community." "Show me this contract," Jennifer said. "It's in the HOA files." The previous owner set up this arrangement and Wesley assumed the obligations when he bought the property. "That's a lie," I said. "I reviewed every document when I bought this place. There was nothing about providing water to anyone." "It's in the CC and Artiques." Jennifer pulled out her tablet. "I have the complete CC and Artiques right here. There's no mention of any water sharing agreement. You're making this up." One of the men behind Brenda, a guy in his 60s wearing a polo shirt, stepped forward. "Look, maybe we can work something out. We can discuss a fair price for the water usage." "No," Jennifer said flatly. "You don't get to negotiate after committing multiple felonies. We've already filed complaints with the sheriff's office and the district attorney. I suggest you all retain legal counsel." "Felonies?" Brenda laughed, but it sounded forced. "That's ridiculous. This is a civil matter at most. Theft of services exceeding $10,000 is a felony in Oregon. Fraud is a felony. Conspiracy is a felony. Trespassing to commit those crimes is a felony. Shall I continue?" The group behind Brenda started looking nervous. A woman in yoga pants spoke up. "Brenda, you told us this was all legal. You said the previous owner had set this up." "He did. The HOA has been managing this water system for years." "Without the property owner's knowledge or consent," Jennifer cut in, "which makes it theft, not management." "I'm calling our lawyer," Brenda snapped, pulling out her phone. "Excellent idea. We'll be serving the HOA with papers tomorrow morning. Now get off this property." They left, Brenda firing off threats over her shoulder about countersuits and harassment charges. When they were gone, I let out a breath I didn't know I'd been holding. "That went well," Dale said dryly. He'd been watching from the well house. "They're going to fight this," Jennifer warned. "People like that always do, but we have the evidence and the law on our side." The question is how deep this goes. Over the next few days, the scope of the situation became clearer. Dale's investigation revealed that the water theft had started about 6 months after I bought the property. The subdivision had been built on land with poor water quality. The developer had promised municipal water connections, but those had fallen through due to distance and cost. The HOA had been struggling with expensive water trucking services when someone discovered that my property had a productive well. According to Dale's interviews with neighborhood residents, most people had no idea where their water was coming from. They thought the HOA had finally connected them to a proper water source. They'd been paying the HOA for water service, which meant the HOA had been profiting from my stolen water. "This is worse than we thought," Jennifer told me in her office 3 days later. "The HOA has collected approximately $800,000 in water fees from residents over the past 4 years. They've been operating an illegal water utility using your stolen resource." $800,000. The residents were paying about $15 per month for water service. 43 homes, 4 years. The math adds up. Meanwhile, your electricity bills for running the well pump were probably thousands of dollars higher than they should have been. I thought about that. My electric bill did seem high, but I just figured it was the cost of living out here. We need to add that to damages. I'm also recommending we pursue criminal charges against individual HOA board members, not just the organization. Brenda Hutchins, in particular, appears to have been the driving force behind this. The district attorney's office took the case seriously. A detective named Sarah Williams came out to interview me and examine the evidence. "This is one of the more brazen theft operations I've seen," she said, photographing the well house setup. "Usually these HOA cases are about fines and petty harassment. This is organized crime-level stuff. Can you prove who authorized it? We're working on that. We've subpoenaed HOA records going back 6 years. We're also interviewing the contractors who installed this equipment. Someone hired them, someone paid them, and there's a paper trail. That paper trail led to a local plumbing company called Riverside Services. The owner, a man named Frank Peterson, was extremely cooperative when the police showed up. I didn't know it was illegal," Frank told Detective Williams, according to what she shared with me later. "The HOA president, Brenda, told me they had permission from the property owner. She showed me documents that looked official. I just did the work I was contracted for." "You still have copies of those documents?" "Yeah, everything's in my files. The documents Frank provided were forgeries. Someone had created fake agreements with my signature authorizing the water connection. A forensic document examiner confirmed that the signatures were not mine and had been digitally added to the documents. This is premeditated fraud," Jennifer explained during one of our many meetings. "They didn't just steal your water opportunistically. They planned this, created false documentation, and executed it. That shows intent, which strengthens both the criminal and civil cases. Meanwhile, the neighborhood was in chaos. Without my well water, the 43 homes had no water source. The HOA scrambled to arrange emergency water deliveries, but those were expensive and inconsistent. Residents started showing up at HOA meetings demanding answers. Dale attended one of these meetings undercover and recorded it. I watched the video in Jennifer's office with a mixture of anger and satisfaction. Brenda stood at the front of a crowded community center, looking flustered. "We're working on resolving the water situation. Mr. Quinn has unreasonably cut off access to a shared resource." Shared resource. A man in the audience shouted, "You told us we were connected to a legal water system. We are. We have agreements." "Then why did his lawyer say you forged documents?" a woman demanded. "That's a misunderstanding. The legal issues are complex. You've been lying to us." Another resident yelled, "We've been paying you for water that you stole from someone's private well." The meeting devolved into shouting. Several residents demanded Brenda's resignation. Others wanted to know if they could be held liable for receiving stolen water. "The residents aren't liable," Jennifer assured me. "They paid in good faith for what they believed was legitimate service. The liability falls entirely on the HOA leadership who orchestrated this." The criminal investigation moved faster than the civil case. Within 2 weeks, the district attorney filed charges against Brenda Hutchins, the HOA vice president Thomas Morrison, and the HOA treasurer Deanne Foster. The charges included theft in the first degree, fraud, forgery, and conspiracy. Deanne cooperated immediately, providing detailed financial records showing how the scheme worked. The HOA had created a separate account for water utility services that had accumulated over $800,000 in revenue. That money had been used for various HOA expenses and improvements, but about $200,000 had been paid out in bonuses to board members for their management services. "They weren't just stealing your water," Jennifer said when she shared this information. "They were profiting personally from the theft. Brenda Hutchins alone received $75,000 in bonuses over 4 years. The preliminary hearing was held in Washington County Circuit Court on a rainy Tuesday morning. I sat in the gallery with Jennifer while Brenda, Thomas, and Deanne were arraigned. Brenda had hired an expensive defense attorney named Richard Blackwell, who tried to argue that this was a civil dispute. not a criminal matter. Judge Patricia Morrison wasn't buying it. Counselor, your client allegedly forged documents, trespassed on private property, installed equipment without authorization, and stole a resource valued in the hundreds of thousands of dollars. These are serious criminal allegations. Bail is set at $50,000 each. Brenda's face went white. Her attorney argued for reduced bail, but the judge denied it. All three defendants posted bail by the end of the day, but the message was clear. This was being treated as serious crime. The civil case moved forward in parallel. Jennifer filed suit not just against the HOA, but against Brenda and the other board members personally, seeking to pierce the corporate veil. Normally, HOA board members have some protection from personal liability, she explained. But when they commit intentional illegal acts for personal gain, that protection disappears. We're going after their personal assets. Brenda's attorney tried every delay tactic in the book, but Jennifer countered each one. We had discovery battles over HOA records, disputes about expert witnesses, and arguments about the scope of damages. Through it all, the evidence kept stacking up in our favor. The neighborhood situation was getting desperate. 3 weeks without water, residents were struggling. Some had moved out temporarily. Others were threatening their own lawsuits against the HOA. The property values in the subdivision were plummeting. Several residents approached me directly, asking if there was any way to work out an arrangement. A delegation of 5 homeowners showed up at my door on a Saturday morning. They seemed genuinely apologetic and desperate. "Mr. Quinn, we had no idea what Brenda was doing," a young mother named Sarah explained. "We're just trying to raise our families here. Is there any way we could purchase water from you legitimately?" I felt bad for them. They were victims of Brenda's scheme too, but I also knew I couldn't just open myself up to more liability. "I appreciate you coming," I told them. "But anything like that would need to be a formal legal arrangement with proper contracts, insurance, and compensation. Talk to Jennifer Caldwell's office. If there's a legitimate way to do this that protects everyone, she'll know." They thanked me and left. Jennifer later told me that several residents had contacted her about creating a legitimate water cooperative, but it would take months to set up properly and would require significant investment in legal infrastructure. "The irony is, if they'd approached you legally from the start, you probably would have worked with them," Jennifer noted. She was right. I wasn't an unreasonable person. If the HOA had come to me 6 years ago and said, "We need water, can we work something out?" I might have agreed to a fair arrangement. Instead, they'd chosen to steal, lie, and then try to extort me. The criminal trial was scheduled for 3 months out, but the civil case moved faster. Jennifer pushed for summary judgment on the liability issues, arguing that the facts were undisputed. "They don't deny installing the equipment on your property," she explained. "They don't deny taking the water. They don't deny forging the authorization documents. The only question is damages, and we have expert testimony on that. There's no reason to drag this out to a full trial." Judge Robert Martinez agreed. He granted partial summary judgment, finding the HOA and its board members liable for trespass, theft, and fraud. The only remaining issue was the amount of damages. That hearing was held 6 weeks after I first discovered the theft. Jennifer presented our damage calculations. The value of the stolen water based on market rates, the cost of the electricity to pump that water, the diminished value and shortened lifespan of my well, the cost of removing the illegal equipment, emotional distress, and punitive damages. Our experts estimated total damages at $1.2 million. The HOA's attorney argued that was excessive, but he couldn't really dispute the underlying calculations. Judge Martinez took the matter under advisement. While we waited for the judge's ruling, the criminal case continued to develop. Thomas Morrison, the vice president, decided to take a plea deal. He agreed to testify against Brenda in exchange for reduced charges. Thomas's testimony was damning. In a deposition I was allowed to read, he described how Brenda had discovered my well while reviewing property records. She'd realized that my property had excellent water rights and a productive well. She'd researched the costs of connecting the subdivision to municipal water versus tapping into my well. The math made the illegal option attractive. Brenda said it would save the HOA hundreds of thousands of dollars, Thomas testified. She said the property owner wouldn't even notice, and even if he did, we could claim it was a pre-existing arrangement. She had someone forge the authorization documents as insurance. Who forged the documents? The prosecutor asked. Brenda's cousin works at a title company. He created them to look official. That revelation led to additional charges against Brenda's cousin, Marcus Hutchins, who also worked in real estate. The conspiracy was wider than initially thought. The civil judgment came down 3 weeks later. Judge Martinez awarded me $1.4 million in damages. He'd added even more punitive damages than we'd requested, specifically citing the forged documents and the attempted extortion. The defendants engaged in a calculated, premeditated theft that continued for years, the judge wrote in his order. They not only stole from the plaintiff, but attempted to blame him for their crimes and extort money from him. This conduct deserves significant punishment to deter others from similar schemes. Jennifer was elated. This is one of the largest HOA judgments I've seen. Now we just need to collect it. That was the hard part. The HOA itself had some insurance and assets, but not nearly enough to cover the judgment. We'd have to go after the individual board members' personal assets. Brenda owned a house worth about $400,000 and had retirement accounts. Thomas had similar assets. Deanne had less, but her cooperation might protect her from the worst of it. Combined with the HOA's insurance policy limits of $500,000, we might actually collect most of the judgment. The HOA filed for bankruptcy, which complicated but didn't prevent collection. Jennifer hired a specialized attorney to navigate the bankruptcy proceedings. Meanwhile, the criminal trial approached. Brenda rejected several plea deal offers, insisting she'd done nothing wrong. Her attorney seemed to think he could convince a jury that this was just an HOA dispute that had been overcharged. The trial lasted 5 days. I testified on the first day, explaining how I'd discovered the theft and the impact it had on me. The prosecutor was a sharp woman named Rebecca Kim, who methodically built the case piece by piece. She presented the forged documents, the testimony from the plumber who installed the equipment, Thomas Morrison's testimony about the conspiracy, financial records showing the illegal profits, and expert testimony about the value of the stolen water. Brenda's defense attorney tried to argue that she believed the arrangement was legitimate, but the forged documents undermined that claim. If she thought it was legitimate, why forge authorization? The jury deliberated for 6 hours before returning guilty verdicts on all counts: theft in the first degree, fraud, forgery, and conspiracy. Brenda sat stone-faced as the verdicts were read, but I saw her hands shaking. Sentencing was set for a month later. Oregon's sentencing guidelines for theft in the first degree ranged from probation to 5 years in prison, depending on the circumstances and criminal history. Given the premeditated nature and the amount stolen, Jennifer thought Brenda would get actual prison time. She was right. Judge Morrison sentenced Brenda to 4 years in prison, with the possibility of early release after 2 years. Thomas, who had cooperated, got 2 years with work release eligibility. Diane got probation and community service. Justice has been served, the judge said at sentencing. This defendant abused a position of trust, engaged in sophisticated fraud, and showed no remorse. The sentence must reflect the seriousness of these crimes and deter others from similar conduct. Brenda was taken into custody immediately. I felt a strange mixture of satisfaction and sadness watching her led away in handcuffs. I hadn't wanted to destroy anyone's life. I just wanted to be left alone on my property. But she'd made her choices. The bankruptcy proceedings took another 6 months to resolve. In the end, I collected about $800,000 of the judgment through a combination of insurance proceeds, the sale of HOA assets, and settlements with the individual defendants. It wasn't the full amount, but it was substantial. More importantly, I'd made my point. You can't just steal from people and expect to get away with it. The neighborhood situation eventually resolved itself in an unexpected way. After the HOA's bankruptcy and dissolution, the homeowners formed a new organization and approached the county about connecting to municipal water. The county, which had been following the case, fast-tracked the approvals and helped arrange financing. It took 18 months and cost the homeowners a fortune in special assessments, but they finally got legitimate water service. My well went back to serving only my property, as it should have from the beginning. I did accept one compromise. 3 homes on the edge of the subdivision were too far from the municipal connection to be included affordably. I sold them water access easements for fair market value, with proper contracts, insurance, and metering. They paid me a reasonable monthly fee, and I used some of the settlement money to upgrade my well system to handle the additional load safely. Jennifer made sure those contracts were airtight. "No more surprise water theft for you," she said with a smile when we signed the agreements. I also used settlement money to sue the developer who had sold the subdivision properties without proper water access in the first place. That case settled quickly once the developer's lawyers saw what had happened to Brenda. I got another $100,000, which I donated to a legal aid foundation that helps people fight HOA abuse. The whole experience changed me in some ways. I'd always been a fairly trusting person who assumed people would generally do the right thing. Now I check everything, document everything, and don't take anything at face value. I also became something of a local legend in property rights circles. Jennifer referred several other clients to me who were dealing with HOA issues. I couldn't help with the legal aspects, but I could share my experience and warn them about the tricks HOAs might try. One case particularly stood out. A woman named Paula Bradley had an HOA trying to force her to remove solar panels from her roof, claiming they violated aesthetic guidelines. After hearing my story, she fought back hard with a good lawyer. The HOA backed down when they realized she wouldn't be intimidated. "You inspired me," Paula told me when she came by to thank me. "If you could stand up to people who were stealing your water for years, I could stand up to people complaining about solar panels." I was glad to help. These HOA organizations had gotten too powerful and too abusive in too many places. Someone needed to push back. About a year after everything was resolved, I was working in my garden when a car pulled up. A man in his 30s got out and walked over. "Mr. Quinn, I'm David Chen. I'm a journalist working on a story about HOA abuse. I heard about your case. Would you be willing to be interviewed?" I thought about it. Part of me wanted to just move on and forget the whole mess. But another part of me thought that telling the story might help other people avoid similar situations or give them courage to fight back. "Sure," I said. Come on inside. The article David wrote was published in a national magazine 3 months later. It was a long, detailed piece about how HOAs had evolved from simple neighborhood organizations into powerful entities that often operated with little oversight. My case was the centerpiece, but he included several other examples of HOA abuse. The response was overwhelming. I got emails and letters from people all over the country sharing their own HOA horror stories. Some asked for advice. Others just wanted to vent. A few were dealing with situations similar to mine and wanted to know how I'd fought back. I couldn't respond to everyone individually, but I did work with Jennifer to put together a guide on property rights and HOA limitations. We made it freely available online. It covered things like understanding your deed and title, documenting everything, knowing when to get a lawyer, and not being intimidated by threatening letters. "You've become an advocate," Jennifer teased me. I guess I have. I just wish I didn't have to be. 2 years after the initial discovery, I was finally able to relax and enjoy my property the way I'd originally intended. The well was back to normal operation, serving only my house and the 3 neighbors with legitimate easements. My water pressure was better than ever. My electric bills had dropped significantly. I'd used some of the settlement money to make improvements to my property. I built a workshop, planted an orchard, and installed a greenhouse. The 5 acres felt truly mine again. Brenda served 22 months before being released on parole. I never heard from her directly, though I did hear through the neighborhood grapevine that she'd moved to California to live with family. Her house had been sold to help pay the judgment. She'd lost her retirement savings, her reputation, and 2 years of her life. I didn't feel sorry for her exactly, but I also didn't take pleasure in her downfall. It was just a waste all around. If she'd been honest from the start, none of it had to happen. Thomas Morrison stayed in the area after his work release ended. I actually ran into him at a hardware store about 3 years after everything concluded. He saw me, turned red, and started to walk away. "Thomas," I called out. He stopped and turned slowly. "Mr. Quinn, I'm sorry, I don't want to cause any trouble." "You're not. How are you doing?" He looked surprised that I was being civil. "I'm okay. Working as a handyman, trying to rebuild my life. Good luck with that. Mr. Quinn, I really am sorry about what we did. It was wrong, and I knew it was wrong even then. I should have stopped Brenda instead of going along with it." "Yeah, you should have. But at least you testified honestly. That counted for something." He nodded, looking relieved. "Thank you for saying that. I think about it every day, what we did to you. It was unforgivable." "Maybe not unforgivable, but definitely not forgotten." "Take care of yourself, Thomas." We parted ways. I meant what I'd said. I wasn't interested in vengeance or making people suffer forever. But I also wasn't going to pretend that what they'd done was okay. The legal fallout continued in smaller ways for years. The HOA's insurance company sued Brenda and the other board members to recoup what they'd paid out. The county investigated whether any officials had been bribed to overlook the illegal water system. The plumbing contractor, Frank, faced licensing issues for not verifying authorization more carefully. All of these were consequences of that one decision Brenda had made years earlier to tap into my well, instead of finding a legitimate solution. I sometimes wondered what would have happened if I'd never discovered the theft. Would it have continued indefinitely? Would my well have eventually failed from overuse? Would I have spent years thinking my equipment was just inefficient while the HOA profited from my resource? The thought made me angry all over again, but I tried not to dwell on it. What mattered was that I had discovered it, I'd fought back, and I'd won. 5 years after the initial discovery, I got a call from Jennifer. "Wesley, I wanted to let you know that we received the final payment on your judgment. The bankruptcy trustee liquidated the last of the HOA's assets. You've now collected $920,000 total. That's more than last time you told me. Interest and some additional recoveries. Not the full judgment, but pretty close. How does it feel? Like closure, I said. Thank you for everything, Jennifer. I couldn't have done this without you. You're welcome. It was one of the most satisfying cases of my career. Bad guys lost. Good guy won. Justice was served. That doesn't happen as often as it should. After we hung up, I sat on my porch looking out over my property. The sun was setting, painting the sky orange and purple. My well pump hummed quietly in the background, doing exactly what it was supposed to do, providing water for my home. I'd learned a lot over the past 5 years. I'd learned that documentation is everything, that you can't trust organizations just because they seem official, and that standing up for yourself is worth it even when it's hard and expensive and stressful. I'd also learned that I was tougher than I'd thought. Before all this, I'd been a fairly passive person who avoided conflict. Dealing with the HOA theft had forced me to become more assertive, more vigilant, and more willing to fight for what was mine. The property felt different now, somehow. It wasn't just a place I owned. It was a place I defended and won. Every time I turned on the tap and got clean, clear well water, I felt a sense of satisfaction. This was mine. I'd paid for it, drilled for it, fought for it. Nobody was going to take it from me again. I heard a car on the driveway and looked up to see Paula Bradley pulling in. She'd become a friend over the years, bonding over our shared experiences fighting HOA abuse. "Hey, Wesley," she called out, getting out with a bottle of wine. "Thought we could celebrate." "Jennifer called me about your final payment. News travels fast. Small legal community. Come on, let's toast to property rights and the end of your saga." We sat on the porch drinking wine and swapping stories as the sun finished setting. Paula told me about her latest battle with her HOA, this time over her vegetable garden. I told her about my plans to expand my orchard. "You know," Paula said, "you should write a book about all this. People need to hear these stories." David's article covered it pretty well. A magazine article isn't a book. Think about it. You could help a lot of people understand what they're up against and how to fight back. I considered it. Maybe she was right. Maybe sharing the full story in detail would help others avoid similar situations or give them the courage to stand up when their rights were violated. "I'll think about it," I promised. She smiled. "Good. The world needs more people willing to stand up to bullies, whether they're playground bullies or HOA presidents." We sat there in comfortable silence, watching the stars come out. My property, my well, my water, my peace. It had taken a fight to preserve it, but it had been worth every moment of stress and every dollar in legal fees. I discovered that an HOA had been using my well without permission for years. I'd fought back against theft, fraud, and attempted extortion. I'd won in both criminal and civil court. I'd collected most of what I was owed. And most importantly, I'd sent a message that property owners don't have to tolerate abuse from their HOAs. It was a good feeling, sitting there on my porch with a friend, knowing that justice had been done and my rights had been protected. The well pump hummed its quiet song in the background, and I smiled. Sometimes, standing up for yourself is the hardest thing you can do. But sometimes, it's also the most important thing. My name is Wesley Quinn. I own 5 acres in Cedar Hills, Oregon, with a private well that provides excellent water. It's mine, all mine, and it's going to stay that way.